Welcome back. So we can see that the internal market is an economic concept, but it's constructed by legal means. We need to pay attention to the legal architecture of the internal market, which is based on freedom of movement of the four factors of production. Now, this slide here introduces the key treaty provisions that govern the internal market. All of these provisions are directly effective, according to the Court of Justice of the European Union. And one of the things that it's quite a good idea to make sure that you've got in your notes is a note of the cases in which each of these provisions is held directly effective. That's not the cases that are listed on this slide. That's a piece of work that you'll just need to do independently. And there is also, as I've just said, lots of legislation that creates the internal market. And we'll be studying some of the key pieces of legislation and applying these, along with the treaty provisions, in problem questions in the workshops and in the eventual assessment, the take-home exam. So when we're thinking about the internal market as a legal construct, there are two different modes of operation of law that interact to create the internal market. First, and probably the easiest to understand, the European Union Legislature adopts measures that create single rules of operation for the whole internal market. These can be full harmonisation. For example, if you want to market a novel pharmaceutical in the European Union, you have to have a marketing authorisation from the European Medicines Agency to do that. Or they can be rules that require member states to meet a minimum legal requirement, but allow member states to have higher standards that apply to domestic producers. And most EU internal market law is like this. Second, legal principles of non-discrimination and market access apply. The idea that domestic products, services, producers and service providers must not be treated differently from non-domestic products, services, producers or service providers unless that is justified, and that in principle a product or a service that complies with regulatory requirements in a state in which it is produced or provided must also be allowed to be sold to consumers in another member state. And one of the themes that we'll be returning to again and again is the relative benefits and drawbacks of these legal forms through which the internal market is created. For now, note that negative integration is relatively effective in that it is enforced through private litigation and before national courts, whereas positive integration relies on action by the European Union Legislature and is constitutionally constrained, both substantively. You've studied the competence rules, and don't forget Article 114 TFEU, which is the key competence provision here, and procedurally. Again, you know about the processes that have to be gone through before the European Union can adopt legislation, in particular that the European Parliament has to assent. And again for now, note that positive integration, especially full harmonisation, while creating regulatory certainty, which businesses like very much, has the effect of removing cultural and other differences between member states and potentially of removing differences that are democratically legitimated in a particular member state. And negative integration also risks removing national differences of approach to regulation in an even less legitimate way because it doesn't involve parliaments at all but works through litigation. And of course, only relatively powerful economic actors are able to bring litigation. I'm coming back to this towards the end of the lecture. So, looking in some more detail at positive integration, here we need to be attentive to the European Union's competence to regulate the internal market. And this is found in the specific legal basis of Article 114 TFEU. So you'll want to have the text of that provision in front of you. I'm just going to get mine. So Article 114 TFEU provides, save where otherwise provided in the treaties. Okay, so save where otherwise provided in the treaties tells us that this is a residual legal basis. It may not be used if there is another, better, more specific legal basis somewhere else in the treaties. Save where otherwise provided in the treaties, the following provisions shall apply for the achievement of the objectives set out in Article 26. Okay, so let's have a look at Article 26. What are the objectives that are set out in Article 26? So Article 26 says, the Union shall adopt measures with the aim of establishing or ensuring the functioning of the internal market in accordance with the relevant provisions of the treaties. So Article 114 gives competence for the EU to achieve the objectives of establishing or ensuring the functioning of the internal market. And Article 26 goes on to define the internal market, 26 subparagraph 2, as an area without internal frontiers in which the free movement of goods, persons, services and capital is ensured in accordance with the provision of the treaties. Article 114 then goes on to say the European Parliament and Council, acting in accordance with the ordinary legislative procedure, shall adopt the measures for the approximation of provisions laid down by law, regulation or administrative action in member states, which have as their object the establishment and functioning of the internal market. So the approximation of national measures, national laws, regulation or administrative actions. What does the approximation mean? Well, this was an issue in the ENISA case involving the European Network and Information Security Agency. And the ENISA case confirms that these words in Article 114 are interpreted broadly. And Article 114 gives the European Union Legislature a broad discretion to adopt whatever method is most appropriate to achieve approximation of laws necessary to create the internal market and to sustain the internal market. The European Union had adopted a regulation establishing the European Network and Information Security Agency based on Article 95 EC, which is the precursor to Article 114 TFEU, in an earlier version of the treaties. The role of the agency is to assist the Commission and the Member States, and in consequence to cooperate with the business community in order to help them meet the requirements of network security and information security, thereby ensuring the smooth functioning of the internal market, including all of those requirements set out in present and future specific community legislation, EU legislation. Now, the UK argued that Article 95 EC, now Article 114 TFEU, did not provide an appropriate legal base for the adoption of that regulation. The UK argued that the power conferred on the EU legislature by what is now Article 114 TFEU is the power to harmonise national laws. It is not, argued the UK, a power to set up EU bodies and confer tasks upon them. What is now Article 114 TFEU, argued the UK, gives power to approximate measures laid down by national law. In other words, if the regulation or the directive at issue achieves a result which could have been achieved by all the member states simultaneously enacting identical legislation, that is within the scope of Article 114. On the other hand, if the regulation does something else that could not have been achieved by the simultaneous enactment of identical legislation by each member state, that is to say, it legislates in fields which are beyond the capacity of individual member states, that is not a harmonising measure, and so it falls outside the scope of competence given by Article 114 TFEU. That was the UK's argument. The Court of Justice disagreed. By using the expression measures for the approximation in Article 95, now Article 114 TFEU, the authors of the treaty, said the court, intended to confer on the EU legislature a discretion depending on the general context and the specific circumstances of the matter to be harmonised, as regards the method of approximation most appropriate for achieving the desired result. In particular, said the court, in fields with complex technical features. So the court concluded that the EU legislature may lawfully, relying on Article 114 TFEU, deem it necessary to establish an EU body to contribute to a process of harmonisation, and may establish that EU body. So that's a very broad interpretation of the text of Article 114 TFEU, and that is a standard approach in the court's jurisprudence, which you'll see in a number of cases involving competence and legal basis, which you might already have looked at. So carry on looking through the text. So we've got the ordinary legislative procedure, which you know means qualified majority voting in council, and European Parliament is also involved and may ultimately prevent the measure from being adopted. And then if you look at subparagraph 2 of Article 114, you'll see that there are some exceptions where 114 may not be used. Paragraph 1 shall not apply to fiscal provisions, so anything to do with tax, things relating to the free movement of persons, or things relating to the rights and interests of employed persons. So those have to be adopted on a different legal basis in the treaty. And then in subparagraph 3, the Treaty on the Functioning of the European Union, Article 114, subparagraph 3, provides that the Commission, when it puts forward a proposal concerning health, safety, environmental protection and consumer protection, has to take as a base a high level of protection, taking into account, in particular, any new development based on scientific facts. And within their respective powers, the European Parliament and the Council also have to seek to achieve this objective. So the way that Article 114 is written, the nature of regulation in the internal market has to take a high level of protection for these interests: health, environmental, safety, and consumer protection. The rest of Article 114 concerns a procedure where if a member state wants to deviate from an EU measure adopted on the basis of Article 114, there's a procedure that the member state has to go through if a member state wants to deviate because, for instance, they have specific needs in terms of national security. This is a procedure that has hardly ever been used. You can read up about it in the textbooks. So, as I was saying when I was talking about the ENISA case, in general, Article 114 TFEU, especially as interpreted by the Court of Justice, gives the EU legislature a significant competence to create and sustain the internal market through adopting EU legislation. But it is not an unlimited competence, as the Tobacco Advertising Directive case shows us. So in 1998, the EU legislature adopted a directive harmonising law on advertising and sponsorship of tobacco products. And this was in fact one in a long line of laws that the EU had been adopting to try to regulate the tobacco industry. With some small exceptions, the directive banned tobacco advertising in the EU. And Germany argued that Article 100A, which is now 114 TFEU, was not a proper basis for the legislation. I know it's confusing that these provisions have different numbers at different times in the treaties, but it's important for me to mention them to you because when you go and read the cases don't talk about Article 114 TFEU unless they're cases involving post-Lisbon times. So you need to know that Article 95 and Article 100A are the old forms of what is now Article 114 TFEU, just so that you don't get confused. So Germany argued the legislation must actually harmonise national legislation so as to create the internal market. And given that the only form of tobacco advertising allowed under the directive, advertising at the point of sale, accounts for just 2% of the industry's spend on advertising, in practice, the directive prohibited tobacco advertising rather than creating a single market in advertising services. Second, Germany argued that there were no appreciable distortions to trade involved, and Article 114 should be read in such a way as to require more than just a minimal or de minimis effect of disparate laws on the internal market. Thirdly, Germany argued that Article 114 is not an appropriate legal basis where the centre of gravity of the measure is actually protecting public health, not creating or sustaining the internal market. Now, the respondents argued that there is a market in cross-border tobacco advertising products and services, for instance, in magazines, like those that are on planes, and those planes are making intra-EU flights, or newspapers published in one member state but distributed in another member state. Because of disparate national legislation, advertising agencies cannot offer or devise or put together uniform publishing concepts at an EU level. So the respondents said there is an impediment to the internal market, which the directive removes. Secondly, the respondents argued, and more fundamentally, that the power conferred on the Council by Article 114 is not necessarily concerned with liberalisation of trade only, but rather with market regulation. There are directives, pointed out the respondents, lawfully adopted on the basis of Article 114 that prohibit certain market activities, and there are a number of examples given in the judgment. So directives on tobacco labelling or labelling of food products, a directive prohibiting marketing of dangerous substances, or the directive prohibiting direct-to-consumer marketing of certain pharmaceuticals, or a directive that prohibits TV advertising of tobacco products in the EU. The court held that the directive was not valid because it did not permit free movement of advertising products complying with its provisions, and it did not actually eliminate appreciable distortions of competition. However, what matters more to us is the court's reasoning, which was applied with different results in subsequent cases, and you'll study some of these for workshop 2. Article 114 does not give the EU a general power to regulate the internal market. That's a really important restriction on the wording of Article 114 that the court established in this case. Rather, a measure adopted on the basis of Article 114 must genuinely have as its object the improvement of the conditions for the establishment and functioning of the internal market. A mere disparity between national laws is not enough. There has to be a concrete risk of obstacles to free movement of the factors of production, or an appreciable risk of distortions to competition between market actors, a not level playing field between market actors in different member states. However, said the court, if this is the case, the fact that the directive also protects public health is not enough to mean that Article 114 is not the correct legal basis. And this latter point is important because the European Union's public health competence, which you might already have seen in Article 168 TFEU, is, at present anyway, only a supporting and coordinating competence, not a power to adopt harmonising, binding laws. In subsequent cases applying this reasoning, the Court of Justice upheld, for example, a revised tobacco advertising directive, on the basis that there were obstacles to trade or likely future obstacles, and so the EU could adopt measures based on Article 114, including measures that comply with Article 1143 TFEU, which provides that the EU has to take as a base a high level of safety, environmental and consumer protection, health, safety, environmental and consumer protection, when the EU adopts legislation based on Article 114 TFEU. So that's the positive integration side of the internal market's legal dimension. I reckon it's time for a quick break, and I shall see you in a minute to talk about the negative integration side.